Namaste students. Today we will be discuss about section 24 of Arbitration and Conciliation Act 1996. Arbitration and Conciliation Act 1996 section 24, which is provided hearing and written proceedings. Arbitration and Conciliation Act 94, hearing and written proceedings, statement, oral session, step to be followed, arbitration advice. Section 24 of the Arbitration and Conciliation Act 1996, hearing and written proceedings. Opinion. Unless the parties agree otherwise, the other arbitral tribunal will decide which is hold. The arbitral tribunal will decide whether to hold an oral hearing for the presentation of evidence for or against, to present arguments, or whether the procedure is carried out on the basis of documents and the other materials, provided that the arbitral tribunal organize oral hearing at the appropriate stage of the case at the request of the person concerned. If the parties have not agreed to this, oral hearing will not take place. The parties must be notified in the time of all arbitration sessions and meetings to inspect documents, goods, or other property. All statements, documents, or other information, request presented by one party to the arbitration court must be transferred to the other party. And all expert statements or documentary evidence on which the arbitration court can rely to make its decision must be forwarded, delivered to the parties. Oral hearing. Oral hearing, common reading of section 19, it clear that an oral hearing should be held at the request of the parties, and it is the duty of the arbitrator to look after what has been confirmed. Consultants purchased by the equity trade private limited 2009. In this case, the arbitral tribunal is obliged to hold an oral hearing at an appropriate stage of the proceedings. If one of the parties requests, unless the parties have agreed that an oral hearing will not take place. If the arbitral tribunal rejects the petitioner request to allow an oral hearing on the ground that can be allowed only if the other party agrees. The arbitral award is set aside as in case Rakesh Kumar versus State of HP, Himachal Pradesh, 2005. Next steps, protocol, drafting and preparation of documents, temporary protection orders, security orders, hearing of facts, award, judgment, appeal. The arbitrator is the head of the trial. Is a general proposition. It is always subject to the limitation imposed on it is the arbitration agreement and the limitations imposed by the statutory requirements of law. The court is entitled to avoid the unnecessary delay and expense that such an approach would cause. The court should go ahead and indicate to the parties those areas which specifically wishes to address and which it does not consider relevant to the real issue in dispute. He must always consider the possibility that the parties will prefer to direct channel and cheaply resolve their differences to the arduous time consuming and expensive search for complete justice. It is the duty of the arbitrator to inform the opponent of the information. Section 24, subclause 1 of the Act provides that if the parties seek to give oral evidence before the arbitral award, it must be admitted because the expression holds an oral hearing. At the request of the parties, the court decides whether a party or witness is to be examined on oath or under oath and has the right to administer the oath, or pledge itself. This assumes the parties agree otherwise. If the witness doesn't object to testify without an oath, the objection may be weak. arbitration proceedings, Section 25 of the Arbitration and Conciliation Act, Section 25, negligence of a party, opinion, arbitration, and end of proceeding. So tomorrow we will discuss Section 25 of the Arbitration and Conciliation Act 1996. If you have any doubts to this topic, so thank you. Thank you so much.